Hello everyone, welcome to MastersTeach. And today we are going to discuss company law, which is a part of your paper 4 for LLB, and it is also uh, helpful for the judicial service aspirants. Let us start with the company law. Here we are going to discuss about the introduction of the company, and until the winding of the company we'll discuss step by step, and it is very important for your examination purpose. So, introduction to company law, meaning and scope here. So, we'll discuss company law govern the formation, operation, and dissolution of the company. It regulates the corporate behavior and protecting stakeholder interest. So, this is the thing. Then it has a separate legal entity. A company can sue and be sued its own name independent of its shareholders and directors. Then, corporate personality. Companies possess a distinct legal identity separate from their members, enable them to own property and enter contract. Then, here, Salomon versus Salomon. Okay, a landmark case established that a company is legally distinct from its members, even in single member scenario. This is the introduction to the company's law. Then nature and types of companies. So definition of a company. So it is an artificial legal personal created by the law, having the perpetual succession and the common seal. It has a common seal, it has a perpetuality, it is created by the law, it is an artificial person. Then it is about the company, and there are private company, public company, one person company, like that. There are different companies are there. Private company. So it's restricted to the share transfer. It's have the limit up to 200 only. Prohibits the public invitation for shares or debentures. It is about the private company. And public company can invite for public for shares, requires minimum 7 members in public company and must have paid up capital as a prescribed. Then one person company is simply we can call as OPS. So allows a single person to form a company, and with a limited liability, promoting entrepreneurship and easy for business. These are the nature and types of companies. Then characteristics and kinds of companies. So the key characteristics of a company is it is the artificial legal person created by law, limited liability protecting members, perpetual succession ensuring the continuity. It has the common seals for authentication. The, the shares can be transferable. So basically, when you are saying the company, it is a public limited company. Okay, kinds of company. So statutory company, chartered company, registered company, government companies, foreign companies. These are the thing. Just remember, write these. You're going to get pass in your LLB examination. Then incorporation and incorporate will. So incorporation registered process, how it can be done, how it's going to have the life. So registration process, so it has the filling the necessary document with the register of companies, including memorandum of association, MOA, or articles of association, and in a prescribed form you have to fill. Then once you have filled the form, you're going to have the incorporation certificate of incorporation. So conclusion of evidence of company's existence issued by the register of companies upon a successful registration. Then lifting of corporate veil. So corporate may disregard separate legal entity in case of fraud, tax evasion, or protection of public interest. So here the key distinction is company differs from partnership, no separate legal identity. So like private companies don't have no separate legal identity, but public limited company have. So Hindu undivided family, it is a family based one. LLP, it is a hybrid model structure with a limited liability. This is about the incorporation and corporate veil. Then promoters and memorandum of association. Who is the promoter? Promoter who conceive the business idea and undertake the preliminary setups of the company and bring the companies into existence. They are called as promoters. They are also called as founders. Then memorandum of association. This is a charter document defining the company's constitution, company's powers, and scope of operations. Then clauses of memorandum of association. What is the memorandum of association consist of? It consists of name of the company, where the registered company office is there, what is the objectives, what is the liabilities and capital, and what is the association clauses, etc. It is there in the clauses of memorandum of association. Why it is important? So companies relation with the outsiders limit the powers and protect the shareholders. This is about the promoters and memorandum of association. Then articles and legal doctrine, so which is meant for the internal governing of the company. So articles of association, so it is AOA. Simply we can say that it is the internally regulate the governing of the company, management and members rights and procedural matters. So doctrine of ultra virus, so that means acts behind company's object, clause or void, and cannot bind the company legally. So they cannot go out of the that particular objective or aims. So indoor management, so the articles of association says that how to manage the company. So outside cannot can assume internal procedures are properly followed, protecting third party transaction. If they have the articles of association properly, so that they can be like legally, like other people can do the business with them by looking at that articles of association. Then prospectus and liability. So prospectus is the invitation to the public to subscribe of the shares or debentures of a company. So types of liability: civil liability, criminal liability, misstatements. Okay, statement in lieu. So what is the liability? Civil liability, compensation for losses due to misstatement. If the misstatements are given, they are liable to have the civil. Okay, criminal liability, penalties and imprisonment for the fraudulent in prospectus. If the prospectus is issued with the fraudulent manner, they are going to have the criminal liability. Then misstatement, so when they are issuing the uh, prospectus, they should not be untrue things, okay, or misleading the statement. If they are doing some misleading statement or improper uh, statements, they are going to have the attacking the legal action. So statement in lieu, so filled with the company doesn't issue the prospectus to public. Okay, this is about the prospectus and liability. Members and borrowing powers. So pre-incorporation contract, so contracts made before company incorporation are not binding unless it is ratified after incorporation through novation. Then members, so person whose names are appear in the register of member includes the subscribers of memorandum of association and alerts of the shares. Borrowing powers, so board members can borrow within the limit prescribed by the articles of association and share approvals for the exceeding limits. Then debentures and charges. So debentures are debt instruments, it is not a own instrument. So charges must be registered with the 30 days inside trading is prohibited. Okay, membership and borrowing powers. Then shares and stocks. Here meaning of share. Shares is represent the fractional ownership in a company. It's capital. So it conferring the rights and liabilities on holders. So stock is the fully paid consolidate into one fund. So freely transferable in one domination. Equity shares means shares with the voting rights. They have the voting rights. The debenture holders don't have. Only equity shareholders have the voting share. Dividend depend on profits and residual claims of on assets. Then preference shares with the preferential rights for the dividend payment and capital repayment during the winding up. When the the preference shareholders get the priority when the company is winding up, they'll get their capital first. So that is the importance of preferential stocks, shares and stocks. Okay, then allotment and transfer of shares. So it is discussed in the unit 3. Statutory restrictions. Okay, call on shares, transfer of shares, transmission. So statutory restriction means minimum subscription should be there. The receipt of application, money and filling statement with the register of companies required before allotment. That is the statutory restriction. Then call on shares. So demand by company for unpaid amount on shares made uniformly, all the shares same class. So if there's some, the shares amount will be called in partly first next part like that. So calls on share. Transfer of shares. So voluntary act of the share transferring ownership through proper instrument and registration. Transmission. So it is the automatic transfer of by operation of the law on death, insolvency or lunacy of the shareholder. Transmission up by the law. Okay, in case of the death of the shareholder or insolvency or lunacy of the shareholder. Then share certificate and registration. So share certificate is the prime facie evidence of the title of the shares issued under the common seal with the prescribed time limit. So time of issue. So when the share certificate is, it must be issued within the 2 months from the allotment of the shares or transfer lodgement as per the Companies Act 2013. Then members, register members. So statutory register for containing details like of members, shares held, dates, etc. is mentioned in the share certificate. Rectification. So tribunal can order rectification if the name is wrongly entered. Okay, number of shares are wrongly entered. Okay, so omitted, any omissions are there that can be rectified. Then unit 4 says about the directors and types of appointment. So meaning, what is the meaning of director? Person who appoint to direct, conduct and manage the company affairs. Why they are conducted? To conduct the day-to-day business, to direct the company's affairs. So uh, broad collectively, so board of directors collectively manage the company. Then women's director. So listed companies and prescribed public companies must have at least one woman director on the board. Then independent director. It is the, he is the non-executive director with no material uh, relationship with the company, ensuring that unbiased governance and oversight. Appointment and qualification. So see, directors are appointed by the shareholders in general meeting. They must have director identification number. DIN number should have, they should qualify that particular certification. So not to be disqualified, and must meet the eligibility criteria. These are the directors and types of appointments. Then powers and duties and meetings. So what is the powers of directors? They exercise the powers of the company subject to the articles of association. According to the articles of association, they have to act. Then act provision, shareholders resolution, they can borrow the money, they can invest, they can manage the business. Then duties and liabilities. They should act in a good faith, so exercise duly diligence, avoid conflicts of interest, and company with the fiduciary duties and under section 166. Board meeting. So minimum 4 meetings should be conducted in a year. The gap should be 120 days in a gap. The quorum should be there, notice should be given, minutes should be maintained, and okay, these are the mandatory. Code of independent directors. So as per the schedule 4 describes duties including upholding ethical standards. So they have to acting objectively and safeguard the minority interest. These are powers and uh, duties and meetings of the directors. Then general meeting, why they conduct? Then statutory meeting is there, annual general meeting is there, extraordinary general meeting is there, tribunal powers are there. So general meeting. So statutory meeting, the company must held the meeting within the 6 months of the commencement of the business. Uh, okay, of your company is the statutory meeting, and it should be full. Uh, the statutory report filled within 20 days before the meeting. Then annual general meeting. So it should be held once in every 6 months of a financial year, and maximum 15 months gap is there within two annual general meetings. Then extraordinary general meeting. So if something happen, something, so this is conducted for the to discuss urgent matters. It is conducted between the two annual general meeting. So board or requisitional or with a proper notice should be given. Then tribunal power. NCLT can order meeting impractical to conduct manners as prescribed the act or articles of association. Sometimes tribunal has to conduct the meeting as per the NCLT. Then resolution and corporate social responsibility. So how the resolution, so every meeting they conduct, they have to so ordinary resolution passed by the simple majority of the members present and voting. Special resolution, it requires three-fourths of the majority, and with the 21 days specify in intention. Then minutes, so it is a record, re- uh, written record of proceedings of the meeting signed by the chairman and preserved for 8 years, that minutes. Then chairman and proxy. Chairman presides over meeting. Members can appoint proxy to attend and vote on their behalf of. Then shareholders activism. So active participation of the shareholders in the governance and decision making process. CRM, matlab, what is that? Social corporate social responsibility. So company meeting the threshold criteria must spend at least 2% of their average net profit in corporate social responsibilities activities. So this is the thing. Then art see unit 5, it says about the accounts and audit investigation. So the company has to maintain the proper books of accounts, so they have to maintain the financial statements, okay, comply with the accounting standards. Then audit, so statutory audit by the qualified chartered accountant, it is a mandatory. So auditor must be appointed by the members, and the report must be true and fair views. Then inspection, so members can inspect company's records. So register of company has the power to inspect the books and documents. Investigation, central government can order investigation into the company affairs on sufficient grounds. They like SFIO conducts the serious fraud investigations. Then minorities protection and class action. So minority rule. So general principle that majority decision binds with all the members. So protect democratic function of the companies. Then minority rights. So statutory protection against oppression, right to apply for to tribunal for relief against the prejudicial acts. Then operation and mismanagement. So according to the section 241 and 246 provide the remedies when the company affairs conducted oppressively or prejudicially to minority interests. So class action suits. So members or depositors can file the class action against uh, company or directors for the fraudulent and unlawful conduct. Then a reconstruction merger of the company. So sometimes the company merges and takeovers of other companies. So compromise reconstruction. So arrangement between the company and creditors members require the tribunal approval for the majority concern. Amalgamation. Two or more companies combine to form a new entity or absorb others, transferring assets and liabilities. So mergers and takeovers. So mergers companies combines as equal. Takeovers involves acquiring controlling stake of in a target company. So these are the things about the reconstruction merger takeovers. So winding up, that means closing up of company or insolvency. Winding up means so process of dissolving company. So setting liabilities, distributing assets, and ceasing existence. Mode of winding up, it may be voluntary by the creditors, tribunal, or by the NCLT. Okay. consequence. So business is going to be closed, liquidator appointed, and assets sold off, then credits will be paid and companies will dissolve. So as per the Indian bankruptcy code, okay, 2016 insolvency and bankruptcy code provides the time bound resolution process for the incorporate corporate insolvency, creditor driven process, 180 days or 270 days life timeline, liquidation if the resolution fails. So this is about the uh, Companies Act. Okay, you can watch this video again and again, and it will be helpful to you to pass in your examination. So this is about the company law. Do subscribe and share with your friends, and it will be useful to your uh, law career. Thank you. All the best for your coming examination.